like we're good to go there. And I'd like to introduce our two presenters today. We have two great presenters from Legal Services of Northern Virginia. So I'd like to start by introducing Terrence Williams. And Terrence, you can just wave. Yeah. Hey, Terrence. So Terrence is the staff housing attorney for Loudoun County at Legal Services of Northern Virginia, serving in this role since just February of 2022, just a couple months, but has really hit the ground running and is already doing great work here in Loudoun. He graduated from Liberty University School of Law in 2020 and obtained his undergraduate degree in Politics and Policies and International Relations from Liberty University in 2016. So Terrence is actually going to be doing most of the presentation, and in just a moment I'll make you the presenter so that you can share your PowerPoint. But we also have with us today Flor Salvador from Legal Services of Northern Virginia. Flor is the housing chair at Legal Services. She's worked at LSNV for almost 10 years and practices in the areas of housing, consumer, and elder law. Prior to becoming housing chair, she was the managing attorney of the Loudoun office for LSNV. She's a graduate of the Catholic University of America, Columbus School of Law, and during her attendance, she was an editor for the Journal of Law, Philosophy, and Culture. She obtained a certificate of study from the Comparative and International Law Institute, and she received an award for student leadership. Flor was born in El Salvador and has lived most of her life in Virginia. And we're so thankful to both Flor and Terrence for providing really great up-to-date information about the Virginia Residential Landlord and Tenant Act. I always forget one of those words, and eviction laws, which are changing all the time. So I'm going to go ahead and make Terrence the presenter, and we'll get started. So that should have happened for you now, Terrence.
Yes,
all right.
I see it.
Great. Thank you all.
Great. Thanks, Chris. So we're actually going to be co-presenting. My colleague Terrence and I have been working on this presentation and we've divvied it up. And so just to start off with, we're going to be doing an overview of the VRLTA, Virginia Residential Landlord Tenant Act. And Chris, I usually forget a word too, so that's why I just use the acronym. So whenever we say VRLTA, it just means the Virginia Residential Landlord Tenant Act and an overview of the ever-changing eviction laws. Next, please. And I just wanted to quickly discuss or provide an overview of Legal Services of Northern Virginia. We are a nonprofit legal aid organization, the largest in Virginia, and we help clients who are low income, no income, or disabled or elderly in civil legal matters. So unfortunately, that means that we don't provide assistance with immigration laws, traffic laws, criminal laws. But what we do is we serve the region's low income and neediest populations in areas that include consumer, elder, family law, human trafficking law, housing law, public benefits, child advocacy and education law. We also have a veterans law project to assist veterans, and we support re-entry for persons who may have been imprisoned and they're trying to return into the communities. Next, please. And as attorneys, we always have to provide a disclaimer. This information is not legal advice, this is just legal information. We can't, unfortunately, provide legal advice in this forum, basically because we have a duty of confidentiality to folks and we have to screen people for conflicts. However, if people have questions at the end, we encourage you to ask general questions and not specific questions that might require legal advice. And an example of that might be, for example, if a tenant says, I have an oral lease, is that okay under the VRLTA? That's requiring legal advice. It's very specific to your situation. But if you were to change that a little bit and just say, are oral leases allowed under the VRLTA, then we can talk about that. or vice versa. For example, if there's a landlord on here that says, I have a tenant who, so that's already setting it up for legal advice. But if you ask a general question like, are landlords allowed to do this under the VRLTA or something like that, then that's a general question we can discuss. Next slide, please. Okay, so the source of law is typically going to be for leases is typically going to be Virginia Residential Landlord Tenant Act and the lease itself. The VRLTA covers all residential tenancies, and I just wanted to note that a few years ago that was not the case. A few years ago, in order for the VRLTA to apply, the landlord needed to own, I think it was 3 or 4 units. Now it's across the board covering all residential tenancies. And it starts off with definitions defining who a tenant is. And it also explains that the chapter will apply to occupancies in single, family, and multifamily dwelling units. And it includes some exceptions. For example, it doesn't cover campgrounds, fraternities, and others. And it also states, there's a section on there that states what prohibited provisions there are in rental agreements that shouldn't be included. So it's really important to be able to find these when you're looking at them on your own. And there's also a section for landlord duties and responsibilities and tenant responsibilities. And, there's also notice requirements for evictions. And there's a section on rights and responsibilities that need to be provided for tenants. So there's a lot that this covers. However, we just included a couple of these bullet points in case people wanted to look this up on their own. You can look up the law basically online. There's a free search engine online, or we always have our Loudon library, which is a great resource. Next, please. Okay, so let's start off with just applying. There's application fees versus application deposits. When a tenant is applying for new housing, it's important to know that an application deposit is refundable and an application fee is non-refundable. So a deposit, if, for example, the applicant fails to rent the unit, the landlord is required to refund the applicant within 20 days all of the money in excess of any actual out-of-pocket expenses or damages that the landlord incurs, and with an itemized list of any expenses and damages. Whereas a fee, as I said, is non-refundable. An application fee cannot exceed $50 exclusive of out-of-pocket expenses paid by the landlord for performing, for example, a background or a credit check or other types of check. However, where the application is being made for a dwelling unit that is for public housing or another housing unit that's subject to regulations by HUD or the U.S. Department of Housing and Urban Development, the application fee cannot exceed more than $32. Next, please.
So I'm going to walk you all through a story. Just hopefully it will help make everything a little bit more clear and easier to understand. So this is Jane Doe. Jane is a single mother who lost her job during the start of the pandemic due to COVID. Her daughter's name is Jackie. Not only did her place of employment permanently shut down because of COVID, she also contracted the virus herself. She wasn't able to pay her rent and got evicted from her home. Jane was lucky to be able to move into with a relative for a while. Jane has now since recovered and has a full-time job as a nurse. Jane is now ready to get back on her feet and move into her own apartment. But Jane is having a problem finding housing. This is Larry Landlord. Larry is an owner of a luxurious apartment complex in Leesburg, Virginia. He's owned the apartment complex for a number of years, but recently hired a new manager, Newt employee. Jane is filling out a rental application. So the apartment Jane wants to rent and apply for wants to charge her $55 for application fee and $200 for the application deposit. Jane is concerned because she checked the VRLTA, and the maximum that a landlord can charge, apart from the actual costs of the screening, is only $50. Jane informed Newt that the application fee shouldn't be more than $50. Newt didn't realize that there was a typo and made the proper corrections to the application fee. Jane finds that she likes the apartment and decides to move in.
Thanks, Terrence. And the important thing there was that the $50 the landlord kept, and then the deposit was refundable if they wished. All right. New tenant screening procedures. So landlords who own 5 or more rental units cannot take any adverse action against an applicant for tenancy based solely on the payment history or an eviction for non-payment of rent that occurred between March 12, 2020 and up through 30 days after the end of the COVID-19 emergency. If landlords don't comply with this section and were to deny someone tenancy illegally, an applicant can file a lawsuit and recover $1,000 in statutory damages and ask that the landlord pay the tenant's attorney's fees for failure to comply. Next, please.
Oh, the new screening procedures that are around until July 1st, 2028. While applying for a rental application, Jane was worried that her previous eviction for non-payment of rent that occurred on May 3rd, 2020, would affect her chances of moving into the apartment. Larry, who owns 5 or more rental units, doesn't know that he cannot deny a tenant access solely based on the payment history or eviction due to non-payment of rent that occurred during the pandemic. Larry, however, does provide written notice of the application denial that includes a statement of rights to contest the denial, the statewide legal aid telephone number, and websites. In this case, Jane must assert her claim within 7 days of written notice of the rejection or the close of business next day if she received the rejection via email.
So the important thing to point out there is that the denial also needs to include that information in writing and allow the tenant to dispute it as well. And so leases as of July 1st, 2019, landlords under the VRLTA, landlords are required to offer written leases. However, if no offer is made, the law still sets out specific lease terms that will apply to an oral lease. For example, an oral lease will be 12 months long without an automatic renewal. Rent needs to be paid in 12 monthly installments due on the 1st of the month and can be late after the 5th of the month. A reasonable late fee may be charged. The security deposit can be no more than 2 months' rent, and that applies across the board, not just for oral leases. And the landlords and tenants can still enter into a written lease afterwards. Next, please.
Okay, so leases and security deposits. At first, Jane and Newt verbally discuss the details of the lease and security deposit. Newt says for a 2-bedroom apartment in Loudoun County, the rent will cost her about $1,300 a month, but he also wanted a $2,600 security deposit. So Jane thinks the security deposit is a bit high, but she knows that under the VRLTA, the landlords can charge up to 2 months' rent for a security deposit. So she accepts the terms. Now, a security deposit is held by the landlord until you move out to cover the cost of damages above reasonable wear and tear that you happen to make to an apartment or a house while you're living there, any unpaid rent or other charges that you owe. The landlord's required to return the security deposit within 45 days after you move out, or provide you with a list of damages and other charges that explain how the money was used and why it wasn't returned.
Yeah, so if we can take that example a step further, and let's pretend Jane, when she leaves the property, they had, the property had a beautiful, perfect, pristine, like new white carpet. And, Jane, she did her best. She'd always, dry off her shoes before going in, but this beautiful white carpet is looking like a shade of beige instead of beautiful white. So when she leaves, that would be considered reasonable wear and tear. But let's just take the scenario a step further, and let's pretend Jane's daughter was trying to heat up some s'mores on the carpet and set up a little mini fire, and the carpet caught fire. That wouldn't really be considered reasonable wear and tear. That would probably be considered a damage. And so then that type of damage could be deducted from a security deposit. And in this case, because the carpet was new, then that would be taken into account in the cost to the landlord. Let's say that carpet was 20 years old and ready to be replaced anyhow. It wouldn't really cover the cost of a new carpet, but a depreciated carpet, the value of it being a 20-year-old carpet, that's what would be deducted. Okay. Statement of tenants' rights and responsibilities. As of July 1st, 2020, a landlord needs to give the tenant the statement of tenants' rights and responsibilities when the tenant enters into a lease or renews a prior lease. You see a copy of this right here. It needs to be signed by both the landlord and the tenant. And the VRLTA actually states that the landlord cannot sue or file a case against the tenant if the tenant was not given a copy of the statement. So they can't maintain a lawsuit until the tenant actually received, unless the tenant actually received this. The statement is available on the Department of Housing and Community Development website, or DHCD website, which can be accessed here via hyperlink, or you can just Google it and check it out. But it's really interesting because it also provides a statement of rights, including application fees, the example we talked about, the $50, and it talks about written leases, security deposits, receipts if the tenant pays by cash or by money order. Money order is considered to be the same as cash. Then a written receipt must be given, and other important rights. So it's good to look that up. Next, please.
Verbal versus written leases. Larry realizes that his new employee forgot to buy more paper, so he couldn't print out a copy of the lease. Jane knew that if there was no written lease agreement, the VRLTA would automatically make the lease term set for 12 months with no automatic renewal period that's paid once a month. Larry always keeps a stack of papers in his trunk, so he prints off a proper lease for Jane to sign. So this lease agreement is for 13 months and becomes a month-to-month lease after the end of the term. Jane knows that that a lease can be for whatever duration the parties agree to. So it could be month to month, week to week, for a period of 6 months, or whatever they decide. Larry also gives Jane a statement of rights and responsibilities, and this must be signed by both parties. It is required before the tenant can be sued. Late fees. Jane's lease also states that if rent is not paid by the 5th of the month, late fees up to 10% can be charged. Now, Jane knows that under the VRLTA, the VRLTA only allows for late fees if the lease provides for them. She also knows that late fees can't exceed 10% of her monthly rent or 10% of the remaining balance if partial payments were made. For example, Jane had extra expenses for this month, so she was only able to pay $300 towards her rent. The VRLTA will only allow a 10% late fee on the remaining $1,000. So the late fee would be $100. It couldn't be more than that. So Jane and Jackie happily move into their new apartment, and they've been living there with no problems. So tenant and landlord responsibilities. Jane and Jackie are enjoying their new apartment, but there are a few responsibilities that they have as tenants. Some of these responsibilities include keeping the dwelling unit clean and in safe condition, regularly taking out and disposing of trash from the apartment, and to use the appliances in a reasonable manner. Larry, as the landlord, has some similar responsibilities. He has to maintain in good, safe working condition, the electrical, plumbing, appliances, heating, AC unit, and other, etc. He has to keep common areas clean and in safe condition. And he has to make repairs to the premises to keep it in a fit and habitable condition.
Thanks, Terrence. And if I could just also add a little bit to that late fees provision. So sometimes folks or tenants might also have a Section 8 voucher, and they're responsible for a certain portion of the rent. So housing authority would pay, let's say 70% of the rent, and the tenant would pay 30% of the outstanding rent. In this case, if the tenant was late on their 30% of the rent, the landlord would only be able to charge the 10% of whatever the 30% of the tenant's portion of the rent, if that makes sense. Okay, maintenance. Landlords are required to maintain fit and habitable premises. However, tenants beware. You are not allowed to withhold rent if landlords fail to make critical repairs. Vice versa, landlords also are not permitted to withhold making repairs if the tenants haven't paid rent. If the tenants have been requesting repairs and nothing is still being done to make the repairs, tenants have two options. One is they can file a tenant's assertion in court, or they can take advantage of the repair and deduct laws. Next. Tenant's assertion. What this is basically it allows a tenant to file a lawsuit in court if the tenant is living with conditions that are considered a material non-compliance of the lease. What this would allow the tenant to do if they're successful in court is the judge could order the landlord to make the necessary repairs. The judge could abate the tenant's rent, or if the conditions are bad enough, the judge could also just terminate the lease. In order to take advantage of this, the tenant needs to send the landlord a written notice requesting the repairs, give the landlord a reasonable amount of time to make the repairs. The VRLTA actually states that anything 30 days or above is presumptively unreasonable, it should say, whereas emergencies like raw sewage should be fixed immediately, though. If the landlord doesn't then make repairs, then the tenant can file a tenant's assertion. That's that form, DC 429. And the tenant would need to pay rent into the court within 5 days of the due date. Next, please. The other option is, let's say the tenant doesn't want to take that route into court. Then there is what's called the repair and deduct law, where again, if the tenant is living with conditions that constitute a material noncompliance with the lease or law, the tenant can repair and deduct the cost by first providing a written notice to the landlord of the conditions that need to be repaired. Tenant needs to wait 14 days, meaning giving the landlord that time to look into it and start making repairs. If the landlord doesn't take reasonable steps to make the repairs, then the tenant can contract with a third-party licensed contractor or pesticide business to complete the repairs. The cost cannot be more than $1,500 or 1 month's rent, whichever is greater. After that, the tenant can then deduct the cost of repairs from the next month's rent by providing the landlord with an itemized statement and all of the receipts. Next.
Okay, Now here's a quick example of how this would play out. So Jane's washing machine stops working. She sends a request in writing to Newt to fix it, but doesn't hear anything back from him for 10 days. Jane's starting to get worried, but she knows that what her options are under the VRLTA. If nothing is done within the 14 days of giving the landlord notice, Jane can have the washing machine paid for or repaired by a third party, so long as it doesn't cost more than $1,500 or 1 month's rent, whichever is more. So Jane's brother could make the repairs, but he's not licensed. So Jane looks up a licensed contractor on the Department of Professional and Occupational Regulations website to see who's licensed, who can make the repairs. There's a link to the website there in there as well. So once the repairs are made, a tenant can deduct the cost of the repairs from their next month's rent. This can be done if the tenant didn't cause the condition that needed to be repaired, denied the landlord access to make the repairs, or the landlord makes the repairs prior to the tenant's repairs. Jane knows that when living conditions are not in compliance with the lease agreement, she can notify her landlord to make the repairs within a reasonable time. Jane's plumbing erupts and raw sewage is leaking from the toilet. Jane sent notice in writing to the landlord to have about them, the raw sewage. Newt said that he would look into it eventually. Jane contracted a licensed contractor, and found out that the repairs would be more than $1,500 or 1 month's rent. So she decides to check a few days later and finds that no progress has been made. So Jane decides to file a tenant assertion and starts to pay rent into the court. 6 months later, something drastic changes. It's the 5th day of the month and Jane hasn't paid her rent. Newt finds it strange as she's always paid her rent on time for the last 6 months. Newt shrugs and prepares to send her a 5-day pay or quit notice. While he does feel bad about it, he's shooting for Employee of the Month and wants everything done by the book. Newt runs the notice to Jane's apartment and posts it on her door. Jane is shocked to see the notice. Evictions for 14-day pay or quit notice. Jane has been homesick for the last 3 weeks due to COVID. She caught the Delta variant and has been unable to work. As a result, her job didn't pay her for the week she was sick, and they won't let her come back to work until 2 weeks after she's well. Jane loves her new apartment and wants to avoid being evicted because of COVID again. Luckily, after her previous eviction, Jane's become well versed in the VRLTA, and she realized there was a problem with the notice she received. The notice Jane received was improper. Since the start of the pandemic, the code now requires tenants to be given a 14-day pay or quit notice. Not only that, but they're also required that the landlord gives the tenants the notice of the Virginia Rental Relief Program and apply on their behalf within 14 days of the tenant receiving the notice. The tenants also have a duty to comply with the rent relief application, or landlords can move forward with the eviction. If the landlord owns 5 or more dwelling units, they're also required to offer a payment plan without late fees to a tenant as an alternative option. The notice must give the tenant the number for the local legal aid office, as well as how to reach Virginia 211 for information and referrals. Jane realizes there's a problem and is going to get to the bottom of it. So hypothetical 1, rent relief and mortgage relief program. Jane runs to Larry and shows him the notice. Larry is shocked to see the notice because he's also aware what the notice is supposed to look like. Jane explains her situation to him, and Larry writes up a proper notice and offers to start the rental relief application for her. Jane agrees, and they both start the rental relief application without any issues. So there's also been some changes made due to House Bill 7001. So in order for a landlord to get possession during the pandemic, there are a few extra steps that must be followed until June 30th, 2022. The landlord must first apply for the rental assistance on behalf of the tenant within 14 days, and both parties have to cooperate with the application. The landlord must also provide documentation needed to complete the application. like the W-9s, IRS form, and other supporting affidavits. They're documents that are needed to complete the application. After the landlord, so if the process is started and the tenants either not complying or other issues arise, the landlord can still get possession if the tenant refuses to apply or cooperate with the landlord's application. The application for rental assistance is not approved within 45 days of submitting a completed application, or 14 days after any subsequent applications.
Thanks, Terrence. And so, in order to apply or to qualify, the tenant needs to have a valid lease. And so, valid leases, they allow oral leases, but they would just need it to be in writing. And so, basically, the program states that even if it's a handwritten lease memorializing what the oral agreement was, they will accept those, or other document showing proof of a lease or residency agreement. And so let me explain that. So residency doesn't mean that the tenant needs to have U.S. citizenship or residency. Tenants can be undocumented and still be eligible to receive rent assistance. The other thing that's required is that the tenant must have experienced a loss of income or increase of expenses due to COVID-19. In this case, Jane lost her, she was affected by COVID. She contracted the Delta virus and was sick again and lost work. So that's a direct correlation. However, the DHCD program is much wider than that. So it says it says a loss of income or increase of expenses due to COVID. And they've oftentimes said an increase of expenses could be, for example, you have to pay more utilities than before because everyone's working from home, and that's due to COVID, or an increase in food expenses, or and things like that. And so it can be pretty broad definition. Also, to be eligible for rent relief, the rent must be at or below 150% of the fair market rent within our area. So within our Northern Virginia area, that means that the rent for a studio can't be above $2,185.50, and so on for a 1-bedroom, a 2-bedroom, 3-bedroom, and 4-bedroom. Also, the tenant's gross household income needs to be at 80% of the area median income or below. Meaning in this case, Jane and her daughter, that's a household of 2 people, then Jane cannot make more than $63,700 to be eligible. And that was the case here. Next, please. So the Department of Housing and Community Development is the organization that's distributing the funds, but they have contracted with Gov2Go. These are a third-party vendor that allow, they've created a platform where landlords and tenants can apply for rent relief by applying online on their dashboard, and we have a link for that here. And Fairfax tenants and landlords can apply through coordinated services planning, and that's the phone number right there. And just to explain a little bit, so there are 2 counties in Virginia that decided not to, they decided that they wanted to run their own local program. It was Fairfax and Chesterfield. And so both of them, they have different platforms for applying. But for the rest of us, our counties here in Loudoun, Prince William, Alexandria, Arlington, and other counties, everyone else applies through the Gov2Go platform. The rent relief program will pay past due rent from April 2020 up through the present. They will also pay for 3 months perspective, for 3 months into the future. And also, there is a program that can help homeowners who need assistance with paying their mortgage or for their homeowner and condominium assessments. It also helps people who may own a mobile home with paying their mobile home rent, the lot rent. And so that is done through the Virginia Housing, the VHDA. And here's a link as well for the Virginia Mortgage Relief Assistance. Next, please.
Hypothetical 2. Jane ignores the notice and Larry files an unlawful detainer. Larry saw that Newt's notice was wrong, so he gave a proper 14-day notice and then gave it to Jane. Jane refused to cooperate with rental relief application, so Larry goes to the courthouse and he files an unlawful detainer. So after June 30th, 2022, the 14-day notice requirement will be returned to the previous 5-day pay or quit notice requirement.
Yeah, so let's talk a little bit about redemption. In Virginia, it's typically very difficult to stop an eviction for non-payment of rent once it's started. But once Larry has filed the unlawful detainer, Jane can do what's called a redemption or redeem, in which case the lawsuit must be dismissed as paid if she's able to pay the landlord all amounts owed as of the court date. So that means all of the past due rent, and if new rent is due that month, that as well. Late fees as provided under the lease, and any court costs, and if there's any attorney's fees that were accrued. So as long as all of that is paid up, then it can be dismissed as paid. Or the second option is, let's say Jane went to the county or a nonprofit to help her, and they've decided that they can come up with the amount of money, so they would have to give her something in writing. So when Jane goes to court on that first court date, she needs to show the judge that written commitment from the local government or nonprofit agency promising to pay all of the amount. And in which case, the judge would continue that court case for 10 days. And then whoever promised to pay that amount needs to pay it within those 10 days. Because at the very next court date, the judge will look to see if it was paid. And if it was paid, then they'll dismiss the unlawful detainer as paid. And if it wasn't paid, then they'll allow the landlord to go forward with the eviction process. So, Terrence?
So, Jane missed all of those opportunities to get a judgment, but she has another opportunity to redeem and not be evicted if she pays all the money that's outstanding. This includes the rent, the late fees, court costs, attorney's fees if there's an attorney representing Larry. All this has to be done 48 hours before the sheriff comes to do the eviction. And this can only be done once a year.
So this is what the summons for unlawful detainer looks like. This is the form that would need to be filed with the court to start the eviction proceedings or the lawsuit for evictions. If you look on the right-hand side, it would say the hearing date and time. It's super important to look at that and see when the court date is. In the middle, it would show the landlord's information or whoever is the one who's filing this and suing this, and the tenant's information. On the left-hand side at the very top, it would say Loudoun County General District Court, and it would have the address for the court. And below that, it actually states what the claim is, why the landlord, or in this case, the plaintiff, is filing this unlawful detainer. And it allows little check boxes. So for example, if it's for unpaid rent, there's a checkbox to be checked, and it includes the amount of rent and late fees, any damages, and so on. Or for another reason, is it for a conduct, for example? That can be written there as well. And in the lower left-hand corner, there would be the case disposition that's filled out by the judge. And that would basically explain what the final disposition of this case was. Was Jane able to redeem? So it would say it was dismissed as paid. Or did Larry get a judgment against her, and for how much rent and how much costs? And what did the judge also award Larry a right to possession of the property? Because what an unlawful detainer does is it can do two things. It can award the plaintiff amount of rent and damages, and it also can give them a right to possession of the property again. Next, please.
Hypothetical 3, the writ of eviction, appeal, and the sheriff. So Larry, landlord, gets a judgment for possession for unpaid rent from the judge. He then gets a writ of eviction, and Jane has 10 days to appeal the judgment. Larry can take the writ of eviction he gets to the clerk's office, and the clerk will then give it to the sheriff to execute the writ. Since there's no self-help in Virginia, the sheriff has to be there to oversee the eviction. The sheriff will let the tenant know 72 hours before they are executing the writ, and they'll usually post that on the book.
Thanks, Terrence. So the overall process in Virginia is it starts off, or the eviction process in Virginia, there's a written contract, a lease between the landlord and the tenant. And so earlier we were talking about housing conditions, if the plumbing wasn't working and it was a breach of the lease, what can tenant do? And so in this case, we're looking at when the tenant is breaching the lease and the landlord wants to evict. And so typically it starts off with a notice. And so earlier you heard a 14-day notice or a 5-day pay or quit. And what that is for if the tenant breaches the lease or the contract because they did not pay their rent, then the landlord can issue the tenant a 14-day notice. And on that notice, it'll include the amount of rent that's due and outstanding. And it'll typically say, "Dear tenant, you are behind on your rent. This is how much you owe. Please, please pay this amount of rent within 14 days after you receive this notice. And then, or if you don't, then I will have to terminate your lease and go forward with an eviction." And it says a couple of other things on there, as Terrence was explaining earlier, that now it also needs to include the information for 211, the rent relief program information, and also tell the tenant that the landlord will apply for rent relief and so on and so forth. The other potential notice is that if there was a conduct case, a breach of the lease due to conduct, then the landlord can issue a notice explaining that the tenant has breached the lease due to their conduct and they have 21 days to fix that. Otherwise, after 30, they'll go forward with an eviction. They'll file an unlawful detainer. And oftentimes, just the end of the lease, if it end of the lease with non-renewal, so the lease will oftentimes state that there needs to be like a 30-day notice or a 60-day notice or something like that. And so you want to look at the lease to see how much notice was required and comply with that. There's also an immediate termination notice, basically if there's a non-remediable threat to health or safety, like let's say Jane is brandishing a gun to neighbors and creating a safety hazard, that could be an immediate termination. So it typically starts with a notice explaining what the wrongdoing is before filing something in court. And then once the court process starts by the landlord filing a summons for unlawful detainer, typically in general district court. And the first court date is called the first return, and it's placed on the civil docket. That is not trial. That is typically when the landlord and the tenant go to that first court date. The landlord explains why they're there, if they're suing because the tenant didn't pay their rent. And the tenant can either agree or disagree with that or dispute it. If the tenant disagrees, then they can ask for trial, which will be set on another date. If the tenant's disputing, the tenant can also request what's called a bill of particulars. A bill of particulars requires a landlord to put in writing why they think the tenant why they're filing this eviction. And also oftentimes once the tenant has requested a bill of particulars, then the landlord can also request that the tenant file an answer and grounds of defense, where the tenant would have to explain in writing why they disagree, why they think that the landlord is not entitled to this eviction. Then trial date is scheduled. It could be a week or sometimes more from the first court date. If the tenant were to lose or not prevail at court, then a judgment would be entered against the tenant. If a judgment for possession of the property is entered against the tenant, then the landlord can go back to court and file what's called a writ of eviction. This writ of eviction will be filed with the clerk's office and then sent to the sheriff's office so they can execute that part of it, the actual overseeing of the eviction. The clerk will process the writ, and typically they need to wait 10 days after date of judgment because the tenant has a right to appeal that decision, and they need to appeal it and note the appeal within 10 days from date of judgment. And after that, then the sheriff can go forward and start moving forward with the eviction by putting a notice on the tenant's door with the date and the time when they will return to oversee the eviction, to make sure that the tenant has moved out and moved all of their property, or to see, excuse me, oversee that process if they still haven't finished. And so the sheriff is required to provide at least 72 hours notice, but practically speaking, it's oftentimes more, and it's just administratively difficult and near impossible for them to come back within 72 hours. So it could be a week, typically, what we've seen. And just a note about the 10-day appeal period: the landlord can also request immediate possession, but as long as the tenant was there to exercise their rights and the 10-day appeal period hasn't passed yet, then they still have to wait at least those 10 days before going forward with the writ of eviction. Next, please.
Right. So now we're going to jump into a hypothetical for eviction for conduct. So Jackie got a new stereo for Christmas. However, recently she developed an interest in heavy metal music. While most stereos offer volumes from 1 to 10, Jackie's has a setting for 11. To all of her neighbors' dismay, Jackie likes to play her new stereo nonstop from 6 p.m. to 11 p.m. while her mother's at work. Jane now receives a 2130 notice for a noise dispute. Jane, knowing all there is to know about the VRLTA and knows exactly what can be done. Jane knows that she has 21 days to fix the problem. If she doesn't, then on the 30th day, she can be evicted for her conduct. Luckily, Jane has convinced Jackie that classical music is all the rage these days, and everybody who's anybody is listening to it at the volume of 3. A new 2130 notice would have to be given to Jane before the landlord can evict her, unless the conduct of the notice is the same. So if Jackie realizes classical music isn't as popular as she thought, then another noise complaint could be in the works. If it's the same conduct again, then a straight 30-day notice can be given to the tenant. And the tenant's lease can be terminated immediately if there's a serious violation, threats to safety and health, or any criminal activity. So this is a hypothetical for the termination of a lease. So towards the end of Jane's lease, Larry decides that he doesn't want to renew her lease. So Larry gives her 60 days notice that he will not be renewing the lease. The amount of time, that's the same amount of time that's specified in their lease agreement. Jane knows that the lease says that 60 days notice has to be given. And luckily, there's a newer model of the same apartment in another building. Before the lease ends, the landlord wants to increase the amount of rent. So no changes can be made to the rental agreement unless both parties have notice and consent to the changes. So expungement of evictions. Jane was able to get her previous eviction expunged off her records. Evictions stay on a tenant's record for 10 years and can significantly affect their ability to find new housing. So beginning January 1st, 2022, if an eviction action is dismissed or non-suit is taken, a tenant can petition the court to expunge the eviction off their records after 6 months. And if the court finds that an unlawful detainer was dismissed or non-suited, the court shall expunge the eviction without a hearing. So expungement is just the court removing the eviction off of your court record, so it's no longer effective.
Thanks, Terrence. And so if a landlord locks out, so we discussed earlier that there's no self-help in Virginia, no self-help eviction. But if the landlord purposely locks out the tenant or cuts off their utilities, and in order to evict them informally without going through the courts, or engages in some form of self-help eviction, then the tenant can file a petition for relief from unlawful exclusion. That's the name of the form. And excuse me, there can be an ex parte hearing on that, and the judge can order, for example, if the landlord had shut off the utilities or changed the locks, then an ex parte hearing, the judge can order the landlord to change the locks to allow the tenant to go back into the premises or to turn the utilities back on. And then there would have to be a full hearing. And during that full hearing, the tenant would have to show that the landlord willfully excluded them from the premises. If they can show that, then the tenant can recover actual damages sustained by them. So in this case, for example, if the landlord changed the locks on purpose and the tenant or Jane had to stay at the hotel for a few days, that would be actual damages, out of pocket expenses that she sustained. And it allows her to recover statutory damages of either $5,000 or 4 months' rent, whichever is greater. And if Jane had to hire an attorney to help her with this, then she would also be entitled to have the landlord pay for those reasonable attorney's fees.
So this is an example of unlawful ouster, a utility shutoff, and lockout changes. So Newt is getting reports that some of the front locks of many apartments are sticking and thinks that it would be a good idea to change the locks. Newt changes the locks to Jane's apartment, but didn't leave her with a new key. This would constitute an illegal lockout. Now, Jane knows that under the code, landlords are not allowed to engage in self-help to evict a tenant. And if a tenant is being illegally locked out, they could bring a claim to the court to be heard, but the landlord has to be given notice of the hearing. So these are new laws that are being considered that involve indigent persons and paying bonds. Flora, would you like to cover this one?
Yeah, sure. So we can start. These are a new bill was passed, or I'm sorry, it wasn't passed. A new bill was approved by the House and the Senate and is being reviewed by the governor. And basically that bill would no longer require indigent persons to file an appeal bond for unlawful detainers. And so when a person wants to make an appeal of a judge's decision in an eviction case, they would no longer be required to pay the appeal bond if they are indigent. That's what the original bill stated. However, the governor hasn't approved it and has made a recommendation that the defendants pay the amount of judgment in the monthly installments over 6 months or by the court date, whichever is earlier. And so let me explain a little bit about that. So right now in Virginia, if a defendant has lost a case and they're indigent, typically they can request the appeal bond to be waived due to their indigency status, their lack of being able to pay and have means. they have no means to pay. So they can get that waived so that they can enjoy the rights to appeal that decision and go back to court. However, that's not the case with unlawful detainers. In unlawful detainers, the law actually states that except for in these cases, indigent persons, still they cannot they can't waive the appeal bond. And so legislation had been proposed, and the House and the Senate was on board to try to remedy that so that across the board, indigent persons would be able to waive appeal bonds. However, in this case, the governor didn't approve it and made different recommendations. And so at this point, it's still, we're waiting and seeing what, if anything, actually becomes of that one. Next, please. Yeah, and so also in Virginia, the law previously was that a 5-day pay or quit notice needs to be issued if the tenant failed to pay rent on time. And during the COVID pandemic, the law was changed to increase to allow a 14-day pay or quit notice, thus allowing tenants more time to come up with the money to pay. This new law will actually will stay in effect up through June 30th of this year. Starting July 1st, it'll go back to a 5-day, meaning that there's less time to be able to come up with the money. And there is also a bill that was, we were hoping it was submitted, but it's been vetoed. And this bill would allow localities to, for example, sue landlords to enforce habitability standards directly. And so let me put that into context. And so you all may have heard, of course, not in Loudoun, but some places have what they call slum landlords, where they're just accepting rent, and they're making no not improvements, but they're making no repairs. You know, there's rodent infestation. It's a scary, scary place to live. And so, and they're still making no changes. And so that bill would have potentially allowed the localities through the county attorney to file in court an injunction requiring, you know, those slumlords to make required repairs so that people are living in safe and habitable conditions. However, instead, this bill was vetoed, and the governor noted that it was vetoed because he believed that the localities can already sue, or they can already file something against landlords to enforce habitability standards under the Uniform Statewide Building Code, USBC. And the other big change, while this isn't law, this is the rent relief program. The rent relief program we were discussing earlier. And so they have notified people that they will no longer be accepting new applications after May 15th. So if anyone is waiting to submit their application for rental assistance, we encourage you to submit them as soon as possible and definitely before May 15th. The other thing I wanted to update folks about that is that landlords and tenants were probably already receiving certain notices in the mail stating that the program is going to be requiring people to submit their information using ID Me. And that would require a little video, a social security number, email address, and things like that to apply. The Department of Housing and Community Development, DHCD, they decided that they were not going to do that anymore based on the short time frame in which they were going to accept new applications. They decided not to make any changes, and they're no longer going to use ID Me anymore. So if folks have received those notices, then luckily you really don't have to do anything about it. Next.
Okay, so for protecting the rights of domestic abuse survivors, Previously, landlords didn't have to take into consideration a person's status as a survivor of domestic abuse when reviewing an application to rent. But as of July 1st, 2020, landlords must consider a person's status as a domestic abuse survivor when reviewing credit reports. So this can be shown through a court order, a police report, a letter from a domestic violence program, housing counselor, or an attorney. If a landlord violates the law, the survivor of domestic abuse can recover actual damages, all amounts paid to the landlord, and attorney's fees.
Fair housing. So we wanted to discuss a little bit about fair housing. And so let's say Jane has gone up to the front of the line for a Section 8 voucher and she was awarded a Section 8 voucher. She's notified Larry, the landlord, of the changes. And although Larry likes Jane and as a tenant and is willing to rent to her again, but he doesn't want to deal with Section 8 or the hassles, he says. So Larry refuses to rent to Jane because of her Section 8 voucher. Is this allowed? Well, there's federal and Virginia fair housing laws that protect against discrimination based on a protected class. Those classes include race, color, religion, national origin, sex, elderliness, which is 55 and above, familial status, disability, source of funds, sexual orientation, gender identity, and military status. So it's a lot more involved than this very simple hypo. First of all, a landlord needs to fall under the purview of the fair housing laws, and for source of funds, they need to own, I think it's 5 or more units, and in which case Larry does. But in this case, because he seems to be discriminating against her due to the source of funds, meaning that she is going to get her rent paid in part by the government, by the county, then that would seem to be that it is discrimination based on source of funds and not allowed under fair housing laws. And so it can be very interesting and convoluted, these laws. So we won't venture into that world today, but we do invite y'all, if you want to learn more about fair housing laws, attend the next presentation that Loudoun County will be hosting.
Laura, I just want to jump in to say, yes, that's exactly what that next presentation is about. So Thursday, we will have the Equal Rights Center and Home of Virginia going in detail about that. And also, currently on our website at loudoun.gov/fair housing is a presentation that Fleur gave last year that goes in depth about fair housing protection. So, yes, lots of resources out there. Thank you.
So, no problems for Jane. Jane, being an expert of the Virginia Code, was able to avoid all these hypotheticals and had a peaceful stay in her apartment. She even renewed her lease for another year after the pandemic ended. And Newt was a quick learner, so within a year, he was also very knowledgeable about the VRLTA and became an excellent manager.
Yeah, thanks. So if we provide, again, free legal advice and counsel for eligible persons. If anyone wanted to inquire about our services to see if you're eligible, feel free to apply online at lsnv.org or call us at 703-778-6800. Thank you. Yeah. Thank you. And so before we go into questions, just a quick reminder that we can provide general, non-specific information, and we cannot provide specific legal advice in this forum, but we welcome any and all questions. Thank you.
Thank you so much, Fleur, and thank you, Terrence. And I am going to start. There's already good questions in the chat. So, and I wanted to just note that my colleague Eileen Barnhart is also on the line. Eileen is our CDBG program manager, and she's going to help me monitor the chat. Eileen, can you just give me a yay or nay? You can see the chat and the Q&A boxes?
I can see them and I've been looking at it. I don't see any messages on my end. So I'm not sure. Maybe I don't have access or something. I didn't see anything on question and answers either.
That's
but
okay.
I have been keeping an eye out.
Yeah, I think what's happening, and that's fine. I think just if people do have additional questions, it looks like people have been sending questions privately to me as the host, which is fine. You can continue to do that. I think Eileen will see them if we send them to quote everyone. But there's some good ones in here already, so let me start with those. So the first one we received is, in the case of repair and deduct, is there a reasonable limit to the amount of the repair? An example would be purchasing a $250 washing machine versus a $2,500 washing machine.
Yeah, so that's a great question. So typically the law doesn't state, what a reasonableness standard. And so what it does require is, for example, that there is a malfunction or something that was the duty of the landlord to fix and they didn't fix it. And the limit is either $1,500 or 1 month's rent. That would be the high amount, the limit. But I think that it's also important to note that's not like a windfall. It's like, if all you needed to do was repair it, then I think that's reasonably what you should do, as opposed to like buying a new one because you like it better. And I think while the law doesn't go into that detail and doesn't state anything further than that, and it's really difficult because most of these are filed in general district court, which are courts not of record. So we can't see how judges have weighed in the past. We don't see their written opinions. But just my opinion, being no judge here, I think that there should be a reasonableness standard. And I think, yeah, Terrence, you can tell me what you think, but I think that, the point of it is not to give someone a windfall. It's to get the repairs that were needed so that they're safe in their home.
Yeah, I would agree with that. That being said, so long as it doesn't exceed, the 1,500 or the cost of your rent. I mean, I guess if the machine needed to be replaced, it could be replaced with a higher end one, but you can't take it with you when you leave, so it'd still have to stay. And then there's a matter of if for whatever reason there's disputes, a higher end versus a lower end one, that's as Flor said, that's not there's no case law on that they can really kind of go by, so it's really not completely certain what they would do, so it's a little risky for the higher end one.
Thank you both. This next question, Flora and Terrence talked a good bit about the rent relief program, and I just wanted to clarify. So the rent relief program, as they mentioned, is through the State Department of Housing and Community Development. Your hosts today are with the Loudoun Department of Housing and Community Development. So just to clarify that, we're not the folks who operate that. That's through the state program. Just had some questions about that. So, but there is a question related to that, and that is, I heard that the mortgage assistance has ended. Is it back again?
Yeah, so great question. Thank you, Chris, for that explanation. So yeah, this was before being housed by the state, DHCD, both sides, the rent relief and the mortgage side of it. But then they ran out of money. And so then they got more money back in the funds and they started again receiving those applications. Remind me if I'm wrong, Terrence, I think it was February of this year or January of this year. So as far as I know, they still have money. And I believe that the maximum amount that they will assist with, I think it's up to $40,000. On March 27th, they increased that cap from $30,000 to $40,000. And if folks owe above that, I believe they have to enter into a repayment plan for the difference or whatever it is. But yes, as far as I know, there's still money in that pot.
Great, that's my understanding too. And I was just looking for a link to the website. I'll find it before we end the session for the Virginia Mortgage Relief Program. Great, so our next question is it I'm trying to turn this around so it's not a specific person asking the question. Is it okay for a landlord to propose raising rent by $350 next month when the lease renews? Or a certain amount. We don't even maybe need to address the exact amount.
Yeah, so I think that, it depends. It sounds like you're saying when the lease renews, meaning that the old lease finished and then a new lease is being entered into. So that's the tricky thing, right? And so oftentimes after one lease ends, you're entering into new lease. Yeah, the parties can contract for a new amount of rent, basically. What they can't typically do is that mid-lease, let's say you have a 1-year lease, and then mid-lease, the landlord, says, let's increase the rent instead. Let's increase it $350 or whatever. But you already had a 1-year lease that capped it at a certain amount. They still need to comply by that cap. But when that lease is ended, then typically renegotiations can occur.
Thanks, Terrence. Did you want to add anything on that question?
Sure. As far as the increases, there's not really like a cap on what the increase can be. So even if it's $50 to like $500, it really depends. There's no real limit in Virginia for how much they can increase the rent. So that's one of those areas that's very difficult to deal with, because it almost seems like there needs to be, I guess, at least some direction for both parties, because it seems like there would be an issue for anyone trying to change the rent prices without having a specific law to point to. So yes.
Good point, Terrence. Yeah, there is no rent control in Virginia. So
thanks. Here's our next question. Can landlords charge a separate, non-refundable, quote, processing fee for, quote, preparing the lease if the applicant is approved to rent?
that's a non-refundable. Wait, I might have to hear you say that again. Can you say that?
Sure, happy to repeat it. Can landlords charge a separate, non-refundable processing fee for preparing the lease? And that preparing the lease is in quotes. For preparing the lease if the applicant is approved to rent.
Okay, so there isn't, immediately off the top of my head, there isn't anything that I've seen in the VRLTA that says no. And it sounds like what it could be is basically, it could be, what is it, a deposit, because under the deposit, like you can include things like you can charge for the amount of money that it'll take them for their background check, paying someone, a third-party vendor, to do background checks and other things like that. And so, yeah, I think that that's a really interesting question, and I don't know necessarily off the top of my head, because I can see it both ways, actually, because you can make an argument that the application, processing the lease or the application is what the $50 application fee is for. Or then the other option is, would it fall into like something else, like what is it, the background checks or the other things that can be included like under the other section? So yeah, I don't know, it's a gray area. Terrence, any thoughts?
I do have one. So my thought is that maybe what they're saying for processing fees is likely because they can only charge $50, and then that other amount is minus the cost of the the actual checks. So I'm thinking the processing fee is probably those other checks that they're including. But as unless they really state that, it's hard to say. But that's probably my thought for issues like that, because the other fees that they can charge for are the fees that would be background checks and any other things. So the preparation of the lease can be preparing all of those things. So it really depends on, I guess, more of what the processing fee actually is for. So if it was more like explanation, it would make more sense. But my off the top thinking is, it's probably those other fees that are included that they're allowed to sue or to put in.
Great, thank you both. And the link for the mortgage relief program is in the chat. Someone else beat me to it. Thank you, one of our participants. So that's in there for everybody. And I'll go to our next question. For the legislation that was vetoed by the governor that you discussed in the presentation, in your opinion, do local governments have the power needed to enforce habitability standards?
So that's a good question. I'm actually not 100% sure of what they're already doing. And so in preparation for this, Terrence and I were looking at the uniform building codes to see what authority was already given to the localities to enforce this. And there was some authority, but it's also unclear exactly like the path that it would take or how they do it. And so that's another, I don't know. Terrence, what do you think?
So as far as we got was there's something in this uniform code. I think the closest we got was the Virginia maintenance code. It's in there. I think even in the governor's veto, he puts in the like section 105.6. It kind of describes what localities can do. It seems like there's something in there that can be used by localities to maybe, enforce habitability standards. But I don't know how many cases there have been, or if there's any other precedent set for localities doing this. So it would be kind of a new territory because judges may not have seen this or dealt with this before. So it really depends. I think there's probably something in there that can help the counties, and they can do those things, but it's all kind of new territory. So it's going to have to be a learning process for everyone while they're looking to see what can be done.
Thank you. We have so many great questions. I will just say that. So I'm going to try to get to, really, I'm like, I never thought of that one. There's so many good questions in here. We're not going to get to all of them. So I'm going to try to get to most of them. And then I would encourage anyone, like we said, who has individual cases or questions to reach out to legal services through the information that Terrence and Fleur provided. But here's one. Can a landlord evict a tenant for clutter?
So that's a good question, and that's a maybe. Because, it depends, right? So if the clutter is to the extent where it's not it's a health and safety violation, like it's you have so much clutter that it is in front of the windows. You can't escape if there's a fire, or you can't, fire department or fire workers, they can't easily enter into the building because there's so much clutter behind the door that they can't move and things like that. And so potentially, I think that would be an opportunity or a way in which a landlord can state, okay, this is a material breach affecting health and safety, and it's a conduct that can be fixed. So then the landlord can issue a 2130 notice to the tenant saying, hey, this is a breach because it's a health and safety violation. Please remove this clutter from these areas, right? And so it has to be to a material level. If it's like a little bit of clutter, like you leave your socks on the ground and things like that, you didn't put things in a hamper, then no. And then also, the other thing that I want to temper that with is also sometimes here at Legal Aid we'll see hoarding cases as well. And so we've looked into that, and oftentimes that is hoarding issues can be a symptom of a disability. And so in that case, there is, again, fair housing that says you can't discriminate against someone based on their disability. And so oftentimes we can request like a reasonable accommodation to allow more time to fix to remove things so that people can enter easily and exit easily into the apartment or other things, or provide other alternatives to help that person remove the clutter and allow for safety implements to be placed.
I agree with that. And one other thing I wanted to add is there are other examples of conduct cases for 2130. And I know I only did the noise complaint, but smoking in dwellings, kind of blocking the egress and ingress of the apartment. So for clutter, that's to the extent like that could also be one. And then, blocking the, leaving stuff on the exterior, like blocking the hallways, that could, technically be a notice too. So different conduct things all would fall under the same category, for the 2130. So all of those would be examples of that. And apart from that, I think Flor covered the other aspects of this question pretty well. Besides, yeah.
Thank you. The next question is, what would a tenant have to go through before calling their own pesticide company if the landlord contractor is not effective?
So, let's see here. So I'm guessing this is probably under the repair and deduct law. And so let me just quickly look at that slide, unless Terrence, you might have it. And I do believe one of the defenses is, for example, if the landlord was able to finish the repairs before the tenant contracted with someone else. Let me just look really quickly.
Yeah, Flor, related to this question actually is the next.
Yeah.
There's another question, and it's really kind of in the same vein. It's basically asking, can you get a second opinion about a repair?
Okay. So
that's
sounds
not
like
the same question, but the next question is sort of like, with repairs, can you get a second opinion? Or I guess, can you reach out to have the situation resolved? Not for the landlord if they're not doing their job.
Yeah, so if in this case, for example, if the repair has been made but the problem occurs again, then it basically starts the clock again with a new notice. You can give a new notice basically stating this repair was made, however, the problem still exists, and this is what the problem is, and request, and then start again to that process so that you can line it up to get a independent contractor to come in and look at the repairs and things like that. And so that's for the question number one. For the second one, if you can get a second opinion for the landlord, the VRLTA doesn't really state that. It trusts that, if the landlord is making steps or reasonable steps to make the fixes, that they're going to fix it. But if the fixes don't completely fix it and it's still a problem, then it's sort of silent as to what happens next, in which case that's why I'm stating that another new notice would be the appropriate action to state another follow-up. This wasn't completely fixed in X, Y, and Z, and again, what the new issue is. And then that way, in a sense, you're kind of getting a second opinion, because if nothing happens, then you're already looking at another contractor to look into it.
Thank you. Terrence, did you want to add any on that?
I think Florence got that one.
Great. Well, we have 2 minutes left, so I think this is going to be our last question, and just wanted to note that I just put in some links for fair housing resources, including HUD, the Virginia Fair Housing Office, Loudoun County site that basically links to a lot of those resources, and Home of Virginia, which is a Richmond-based organization that also provides resources for fair housing. So I just put that in the chat. And I think our last question will be, from first notice until the actual eviction, on average, how long does it take to evict a non-paying tenant? And maybe you could just talk about that process there.
Yeah, so it really it depends, and it's really been skewed now due to COVID. So typically, before by the time someone issues a 5-day pay or quit notice, then if there's no rent that's been paid and the landlord goes forward with the eviction, then the tenant needs to be served with that. And so you have to include the amount of time it'll take the process server or the sheriff to serve the tenant. And then typically from the date of service, there could be 2 or 3 weeks for like your first court date, depending on how backed up the courts are. But let's start it for us, it's a little bit easier to count starting from that first court date. So that first court date is the first return. And typically a trial, without taking COVID into effect, typically a trial can be within 1 week or within 2 weeks. And then after that, let's just say, for argument's sake, trial was in 14 days. And after that, there's a 10-day appeal period, bringing you to like a 24-day. And then the sheriff needs to go and do the actual eviction part, adding the 3 extra days. And so the reality of it is, if the stars line up and everything is done as quickly as possible, starting from that first court date to the actual eviction, when the sheriff goes to the home, it can be a month. Now, sometimes it can also be longer. During COVID, there were certain laws that allowed a 60-day continuance. And now, while, folks are required to apply for rent relief and are supposed to not file and wait until after 45 days of a completed application. And so if that hasn't happened, then oftentimes judges are allowing continuances for this to allow time for either landlords or tenants to finish applying for rent relief if they didn't do that. And so that can take a little bit longer depending on where that process is.
Thank you so much. Any last words on that, Terrence, before we end this afternoon? I know
I think that's,
you live on a day-to-day basis, both of you.
Yeah, I think that's a pretty good time frame, especially with all the things that are happening. I think a month is probably pretty standard.
Great. Well, it is 2:30, and that hour and a half went quick. And I just want to thank you both, Floor and Terrence, for providing this really important information to all of us. There are a couple of questions in the chat about whether the slides will be available or the recording will be available. That is my plan, is for us to post it online. Just give us a couple days to take a look at it and trim it up if we need to. And if you have questions or follow-up about the presentation, feel free to reach out to me. But if you have questions or need to reach out to legal services, I just put the contact information for LSNV in the chat as well. So thank you, everyone. Have a great afternoon. And again, happy Fair Housing Month.
Thank you.
Thanks, Chris.
Bye.